Good morning, Canada. Alex Monahan here, Foundations Party, ineligible. And as promised, I'm going to continue looking over the Immigration Acts. Today's date is April 11th, 2017. And I guess without further ado, let us begin. Division 2, Examination. Examinations by officer, paragraph 15, subparagraph 1. An officer is authorized to proceed with an examination if a person makes an application to the officer in accordance with this act, or if an application is made under subsection 11, 1.01. Provincial criteria, subparagraph 2. In cases of a foreign nation referred to in subsection 9, 1. An examination of whether the foreign nation complies with the applicable selection criteria shall be conducted solely on the basis of documents delivered by the province, including that the competent authority of the province is the opinion that the foreign nation complies with the province's selection criteria. Inspection, subparagraph 3. An officer may board and inspect any means of transportation bringing persons to Canada, examine any person criteria carried by that means of transportation, and any record of documents representing that person seized and remove the record or document to obtain copies, or extracts and holds the means of transportation until the inspection and examination are completed. Instructions, subparagraph 4. The officer shall conduct the examination in accordance with any instructions that the minister may give. Changing the page. Obligations. Answer truthfully. Paragraph 16, subsection 1. A person who makes an application must answer truthfully all questions put to them for the purpose of the examination, and must provide a visa and all relevant evidence and documents that the officer reasonably requires. Obligations, appeals for examination. 1.1. A person who makes an application must, on request of an officer, appeal for an examination. Obligation, relevant evidence. Subparagraph 2. In the case of a foreign nation, A, the relevant evidence referred to in subsection 1, including photographic and fingerprint evidence, and B, subject to the regulations, the foreign nation must submit to a medical examination. Obligation interview. Subparagraph 2.1. A foreign nation who makes an application must, on requests of an officer, appear for an interview for the purpose of an investigation conducted by the Canadian Security Intelligence Services, under Section 15 of the Canadian Security Intelligence Services Act for the purposes of providing advice for information to the minister under the Section 14 of that Act, and must answer truthfully all questions put to them during the interview. Evidence relating to identity. Subparagraph 3. Any officer may require to obtain from a permanent resident or a foreign nation who is arrested, detained, subject to an examination, or subject to the removal order, any evidence, photographic, fingerprint, or otherwise, that may be used to establish their identity or complacent or identity or complaints with this act. Regulations. Paragraph 17. The regulations may provide for any matter relating to the application of this division and may include provisions respecting the conduct of examination. Division 3. Entering and returning in Canada. Entering and returning. Examinations by officers. Paragraph 18, subsection 1. Every person seeking to enter Canada must appear for an examination to determine whether the person has a right to enter Canada or is not, or may become unauthorized to enter and remain in Canada. Transit, subsection 2. Subsection 1 also applies to persons who, without leaving Canada, seek to leave an area at the airport that is reserved for passengers who are in transit or who are waiting to depart Canada. Right of entry of citizens and Indians. Paragraph 19, subsection 1. Every Canadian citizen within the meaning of the of the Citizenship Act, and every person registered as an Indian under the Indian Act has the right to enter and remain in Canada in accordance with this act, and an officer shall allow the person to enter Canada if satisfied, following examination of their entry, that the person is a citizen or registered Indian. Right of entry of permanent resident. Subparagraph 2. An officer shall allow a permanent resident to enter Canada if satisfied, following an examination on their entry, that they have that status. Obligation to enter. Paragraph 20. Subsection 1. Every foreign nation other than a foreign nation referred to in Section 19 who seeks to enter or remain in Canada must establish: A. To become a permanent resident, that they hold the visa or other documents required under the regulations and have come to Canada in order to establish permanent residence, and B. To become a temporary resident, that they hold the visa or other documents required under the regulations and will leave Canada by the end of the period authorized for their stay. Declaration 1.1. A foreign nation who is the subject of a declaration made under subsection 22.1, subparagraph 1, must not seek to enter or remain in Canada as a temporary resident. Provincial criteria, subparagraph 2. A foreign nation referred to in subsection 9.1 must also establish, to become a permanent resident, that they hold a document issued by the province, including that the competent authority of the province is of the opinion that the foreign nation complies with the province's select criteria. Designation: human smuggling or other irregular arrival. Paragraph 20.1, subsection 1. The minister may, by order, have regard to the public interest, designate as an irregular arrival the arrival in Canada a group of persons if he or she, A, is of the opinion that examinations of the persons in the group provide, particularly for the purposes of establishing identity or determining inadmissibility, and any investigations concerning persons in the group cannot be conducted in a timely manner, or B, has reasonable grounds to suspect that in relations with the arrival in Canada of a group, there has been or will be a contravention of subsection 117.1 for profit or for the benefit of a benefit for, at the direction or in association with a criminal organization or terrorist group. Effect of designation. Subparagraph 2. When a designation is made under subsection 1, a foreign nation other than a foreign nation, a foreign nation dash other than a foreign nation referred to in section 19 dash, who is part of the group whose arrival is the subject of a designation because a designated foreign nation, unless on arrival they hold the visa or other documents required under the regulations, and on examinations the officer is satisfied that they are not inadmissible. Statutory Instructions Act. Subparagraph 3. An order under subsection 1 is not a statutory instruction is not a statutory instrument for the purposes of the Statutory Instruments Act. However, it must be published in the Canadian Gazette. Applications for permanent residence. Restrictions. Paragraph 20.2, subsection 1. A designated foreign nation may not apply to become a permanent resident. A, if they have made a claim for refugee protection but have not made an application for protection until the 5 years after the day of which a final determination in respects of the claim is made. If they have made an application for protection until 5 years after the day on which a final determination is determination in respects of the application is made, or C, in any other case until 5 years after the day on which they become a designated foreign nation. come on. Having troubles with this thing. Suspension of application for permanent residence. Subparagraph 2. Actually, I think that's going to be all for this first half today. And thank you for watching, and I hope you are interested in seeing the other half of this. So stay frosty and keep watching, and we'll get through this eventually.